The regulations require UAE onshore and free zone companies, and other UAE business forms, that carry out any of the 9 relevant activities listed in the law, to maintain an adequate economic presence in the UAE relative to the activities they undertake. Out of 9 relevant activities, we are going to discuss intellectual property business. What is the meaning of intellectual property business, in economic substance regulation? A UAE business is regarded as carrying on an intellectual property business, if it holds, exploits, or receives, gross income from intellectual property assets. Here in the slide you can see simplified definition of IP business. Just imagine, we are situated in UAE, and generating income from intellectual property, like, copyrights, patents, trademarks, brands, and technical know-how, from which the licensee earns separately identifiable income, in the form of royalties, license fees, franchise fees, capital gains, and any other income from the sale or exploitation of the intellectual property asset, and which IP does not fall under intellectual property business. Most UAE businesses will own some form of intellectual property asset, example, their trademark, technical know-how relating to their processes, copyright in their works etc., but not earn separately identifiable income from such assets. Instead, the intellectual property assets contribute to, or protect the value of the goods or services these UAE businesses provide. The ownership of such intellectual property asset would not be considered as carrying on an intellectual property business, as the intellectual property asset is merely auxiliary to the main business of the UAE business. Please note, if there is any indication that a licensee has manipulated its gross income, to avoid being subject to the economic substance requirements as an intellectual property business, for example, by disguising royalties as part of sales income, the regulatory authority shall take the necessary action to ensure compliance with the regulations. Core income generating activities, of an intellectual property business. The regulations set out certain sigas for an intellectual property business. First one, patent and similar assets, and second one, marketing intangibles. The siga required to be undertaken in the UAE, will depend on the nature of the asset being exploited, and how that asset is being used to generate, gross income for the licensee. First one, patent and similar assets, example, that share the same features of a patent, including copyrighted software, technical know-how and other similar novel, useful and protected assets, research and development. This siga includes, planning and documentation of new products, processes or services, prototyping, demonstrating, piloting, testing and validation of new or improved technologies, addressing known scientific or technological obstacles, applying research findings or other knowledge, for producing or introducing new or improved materials, devices, products, processes, systems, technologies or services, etc. Second one, marketing intangibles, an intangible that relates to marketing activities, aids in the commercial exploitation of a product or service, and/or has an important promotional value for the product concerned such as, trademarks, brands, customer lists and relationships, branding, marketing and distribution. Demonstrating S in the UAE for an IP business. In demonstrating economic substance in the UAE, for an intellectual property business, periodic decisions made by non-resident directors would not be sufficient to satisfy the economic substance test. Therefore, it would require more than local staff passively holding intangible assets, whose creation and exploitation is a function of decisions made, and activities performed outside of the jurisdiction. We can see here some of the examples of IP business. ABC Group holds a brand, the rights for which are licensed to others in return for a royalty. ABC Group is within the scope of an intellectual property business. Another example, Nestlé Group has a trademarked range of chocolates, which it manufactures and sells to unrelated third parties. Let's think, sell to unrelated third parties supermarket. Nestlé Group is not an intellectual property business, as its gross income is derived from the sale of finished goods to third parties, not the exploitation of an intellectual property asset, that is. The value of the trademark is intrinsically linked to the value of the chocolates, and is not separately distinguishable, making the use of the trademark incidental. High-risk IP licensee. Where a licensee is carrying on an intellectual property business, it will also have to consider if it is a high-risk IP licensee. A high-risk IP licensee is defined under Article 1 of the Economic Substance Regulations, as a licensee which carries on an intellectual property business, and under Condition A of the definition meets all of the following 3 requirements. 1. The licensee did not create the intellectual property asset, which it holds for the purpose of its business, and 2. The licensee acquired the IP asset from either A group company, or B. in consideration for funding research and development by another person situated in foreign jurisdiction, and 3. The licensee licenses or has sold the IP asset to one or more group companies, or otherwise earns separately identifiable gross income, that is, royalties, license fees, from a foreign group company in respect of the use or exploitation of the IP asset. High-risk IP licensee, non-compliance. Any high-risk IP licensee is, by default, deemed to have failed the economic substance test, resulting in the competent authority exchanging information on the high-risk IP licensee with the relevant foreign competent authorities, where the parent company, ultimate parent company, and the ultimate beneficial owner of the high-risk IP licensee are resident. A high-risk IP licensee would nevertheless be required to meet the economic substance test, to avoid being subject to penalties, by providing sufficient evidence supporting that it has, and has historically had, a high degree of control over the development, enhancement, maintenance, protection and exploitation, the so-called DMPE functions, of the intellectual property asset. IP licensee requirements. The licensee is required to have an adequate number of full-time employees, with the necessary qualifications, who permanently reside and perform their activities in the UAE, and would need to provide the following information. A business plan showing the reasons for holding the ownership in the intellectual property asset in the UAE. Employee information, including level of experience, type of contracts, qualifications, and duration of employment of the licensee. The above information would have to prove that, in the UAE there is more than local staff passively holding intangible assets, whose creation and exploitation is a function of decisions made, and activities performed outside of the jurisdiction. As such, the business would need to evidence that decision-making is taking place in the UAE. Note: periodic decisions made by non-resident directors, or board of members would not be sufficient. We can see here some of the examples of IP business high-risk IP licensee. Pharmacy Corp LLC, a UAE resident company earns gross income from licensing its patent for a new medicine, to its group companies located in Egypt and KSA. Pharmacy Corp LLC did not create the patent, the rights were acquired from a group company, R&D Co. in the UK. Pharmacy Corp LLC is a high-risk IP licensee, and would be subject to the exchange of information provisions of Article 9.3, and be required to provide additional information to evidence its economic substance in the UAE. Need assistance or advice? Please contact RBS at 0501755867, 0545692022, 0565002963. Mail us at rbs@rbsaccounting.com, contact@rbsaccounting.com. Visit us at www.rbsaccounting.com. Thank you for watching.